Mr. Hollis was awarded workers' compensation benefits, received some in Tennessee, and then applied for some here. There's going to be a discussion about whether you can get them in Tennessee and here. But we also need to work through a, threshold question about when should this hearing have been held, because there's this pesky 60-day clock and language that says when it's docketed, and what is the it, and does docketed mean the petition is filed? What if it's never been served? When does the judge learn about it? Or is it 60 days from when? And so I'd like us to talk about both, and we'll see what's left after that. I'll start with you, Ms. Ivey. I assume your position is this is a timely hearing, but that Mr. Hollis ought not to be able to get a second stream of workers' compensation benefits because he was getting them in Tennessee, and he's time barred here because he didn't seek them soon enough here.
That's right. That's right, Your Honor. If you want me to go ahead and sort of proceed on those issues. Threshold issue of whether this appeal is timely. The parties do dispute that. We contend that the date of docketing is going to be the date that the court received the board file, versus I think Mr. Hollis's attorney will be arguing that the date of docketing is when the docket was first created, when the petition for review would have first hit the clerk's office. Excuse me, I'm having technical difficulties with the light. This is what happens when you stay still too long. So in the difference, we would say, and what's important to look at here is a 1997 amendment to the statute. And the statute I'm talking about now is 349105B. Pre-1997, that statute used to say you have 60 days from the time of filing the appeal to have a hearing. And then afterwards, that statute was specifically changed to say 60 days from the time of docketing. And I still think there's some ambiguity there, but I think what is clear is that whatever the date of docketing is, can't be from the time of the filing of the appeal. That's what was said before, so necessarily it must mean something else now. What was going on at the time and what the legislature had to deal with, what the courts were dealing with at the time, was a situation similar to this, where perhaps the board file was not transmitted timely, maybe the clerk did not receive the file timely, or in one of the cases relied on, in some of these opinions that the claimant's attorney puts forward, synthetic industries versus camp. The problem there was a delay in a hearing and a delay in transmitting the board file because there was still some ongoing litigation. So even the court in synthetic industries versus camp, they did hold to the fact that they thought the hearing was not held timely based on when the petition for review was filed, but they even in their opinion said this is an ill effect of the way the statute was written, and that the legislature should rewrite the statute and remove the inequity that was happening there. And again, that's going back, that's sort of that change and that difference that happens between the 60 days running from the time of filing the appeal versus 60 days from the time of docketing, which we would say is when the court, when the clerk stamps and receives the board file. Otherwise, I think you're cutting either party off at the knees of having to try and proceed with this hearing without the file, the claim being at the court for you to hear, for you to review. And one more thing I would point out in looking at this, in workers' comp, one of our foundational treatises is Kasaya and Lay. So I would point to that in section 29.08. They talk about this change in the statute, and they say that before pre-1997, we were counting the 60 days from the time of filing the appeal. But when we changed that language to the date that the case was docketed, Kasaya and Lay even says that's understood. The docketed by the Superior Court is upon its receipt of the record from the state board. And that seems to make the most logical sense to us.
If only they had used those words in the statute.
Well, I guess we should all be happy for ambiguities and having jobs.
Right, right. Okay. I appreciate that. That makes sense. I think I follow that. I understand the other side as well. So tell me then about assuming I have jurisdiction over this and it hasn't been resolved by default, a affirmance of the board's decision from their appellate division. Why should I undo what they decided?
Sure. So the basic facts here are not in dispute. This is a narrow legal issue of statute of limitations. So Mr. Hollis was involved in a motor vehicle accident on April 1st, 2023. He had an accident in Fulton County. And from that, the claim was accepted in Tennessee by his employer, Averitt. Averitt is their principal place of business is in Tennessee. They hire all of their employees out of Tennessee. So generally speaking, they do accept their claims in Tennessee first. I've had many claims. I've represented them for several years. There are many claims where a claimant will pursue benefits in Tennessee, and then they get to a certain point, and then they come here to Georgia to pursue other benefits. A perfect example, and actually what happened here, is Tennessee, we refer to it as an MMI state, maximum medical improvement. Once a claimant hits maximum medical improvement in Tennessee, their law allows for suspension of indemnity benefits, of those weekly TTD benefits. Here in Georgia, that's not the case. MMI doesn't hold that weight. We have to go deal with a separate causation standard. So we see often in these cases that a claimant will pursue the claim in Tennessee sort of until they hit maximum medical improvement. Their indemnity benefits then get suspended, and then they transfer jurisdiction over here to Georgia and they pursue additional benefits. And again, that's what happened here. The problem here, however, is we have a date of accident, April 1st, 2023, but a WC-14 request for hearing was not filed until May 6th, 2025. That also happened to be about 2 weeks after he settled part of his claim in Tennessee. And by that point, he had received roughly $400,000 in benefits in Tennessee. So we come here, we have a hearing request here. Averitt controverted on the basis that OCGA 34982A applies. That statute of limitations says a claimant has to file a claim in Georgia within 1 year unless weekly benefits or remedial treatment are provided for by the employer on account of the injury. And so what I'm sure you'll hear a lot from Mr. Hollis's attorney, what you'll read from the decisions below and the cases that he cites, all of that is very focused on the plain language of those words and the meaning of those words. So Averitt, the employer, did pay him benefits, that's undisputed, did provide remedial treatment. It was all on account of the injury. But the distinction we're making is that all of those benefits were previously paid in Tennessee under Tennessee law. Nothing has ever been paid pursuant to Georgia law. There's been no WC-2 filed commencing benefits here. The claim has proceeded under Tennessee law to date. And overall, it is common, it is understandable, it is certainly a fundamental pillar of statutory interpretation that words should be given their plain meaning. We don't want to twist and turn statutes so they mean something that's not so obvious. But what we would put forward is that it's also equally important to understand the context in which those words are written. And so here, it is very true that 34982A never says the phrase in Georgia. It doesn't say payment of benefits by the employer in Georgia. It doesn't say on account of the injury in Georgia. We don't even say the claim has to be filed in Georgia within a year. But we don't have to say that because what we were talking about this entire time is Georgia law. We're talking about the Georgia Workers' Compensation Act. We're talking about OCGA 3491 et sequential. That is our body of law. And if you even look to other statutes that are critical in workers' compensation, where we derive all our benefits from, examples would be 349200. That deals with medical treatment. When you can get medical treatment, what's paid for 34.9, you can do 261, 262, 263. That's all your weekly benefits. That's your impairment rating, all the benefits, medical indemnity that you could get. None of that says in Georgia. We don't have to keep repeating in Georgia after every phrase because we know that's what we're talking about. And so it's important here to understand that benefits paid by the employer on the account of the injury must be done so in Georgia, pursuant to Georgia law. And I would also point, Your Honor, to Judge McMurray's dissent in one of the cases that comes up in sort of this body of law and what the appellate division has cited previously, Sprayberry versus Commercial Union Company. The dissent sort of said it best. That case was all about deciding whether the employer could take credit for benefits paid in another state. And indeed they can. Indeed, we have dual jurisdiction. Our statute contemplates that. No dispute there. But Judge McMurray then said payments made by the employer must mean payments made under the statute. And if no claim is filed, then payments otherwise made by the employer cannot be considered payments under the statute. That makes sense. And further, sort of the reason this makes the most sense, if you take this idea to the logical conclusion, the misstep that the appellate division has taken, not only in our case, but in a 2011 opinion that has come up in this case, and you'll see it referred to in our briefs, when they say they're looking so hard at the plain language and payment by the employer on the account of the injury, that they then take this next leap and say, in their opinion, that even payments made by the employer, that includes payment of benefits pursuant to workers' comp laws of any particular state. And that is a very broad, way too far thought that goes far afield. So keeping in mind in workers' comp, payment of certain benefits triggers when a claim is compensable, or also in this case triggers when a statute of limitations applies. And so to be consistent, if you say payment of weekly benefits in Tennessee counts as the same thing as payment of weekly benefits in Georgia for the statute of limitations, you must also be saying that payment of benefits in Tennessee controls when a claim is accepted in Georgia or not. And that could be Tennessee, that could be anywhere. That could be California, that could be New York, Texas, Florida, anywhere. And the statutes are wildly different. And it's more than just administrative details here. What we're talking about is when certain benefits are owed, how much are owed, when an employer is obligated to pay these benefits. And so you quickly hit very bad consequences if you say payment of benefits in another state tolls the statute of limitations here, because now you're letting the laws of another state control not only the statute of limitations here, but compensability here, and when benefits are owed here. Moreover, you're going to hit another inconsistency, because if you allow payment of benefits, and this is this case, payment of benefits in Tennessee works to bar the statute of limitations here. That's what the claimant wants. However, he doesn't want the denial of benefits to apply to his case. We have Tennessee denying further indemnity benefits because he's hit MMI. But that's not the law in Georgia. So are we going to allow the law in Tennessee, payment of benefits in Tennessee, to control our law but not control a denial? That doesn't make sense. And if you're wondering, well, how could this ever really work? How does dual jurisdiction play out? The one thing that should have been done here that wasn't was filing the 14 within a year. If a 14 request for hearing or notice of claim was filed within Georgia within 1 year, we wouldn't be here.
So what would happen? You and Mr. Adkins are the subject matter experts with workers' comp. Let's say Mr. Hollis applied in both Tennessee and Georgia simultaneously. He sees, sure, I've got a hook in both. The accident was here in Fulton County, but Averitt's pretty much a Tennessee company, and that's where they tend to handle a lot of their workers' compensation claims. So I'll file them both. What happens when something like, would a Georgia administrator of workers' comp say, oh, you know what, you got to start in Tennessee because that's the domicile of the corporation. But you've stopped the clock, but nothing happens? Or would he be getting a stream of benefits from both states?
Right. So that would not happen. Alex can certainly address this too when it's his time to sort of give his side. Alex is actually barred in Tennessee, so he would be even more of a subject matter than I would. I'm not barred in Tennessee, but I deal with this issue a lot because this is one of our primary clients. So it's my understanding, I think Alex can confirm, that Tennessee actually has an election of remedies law. So once you pursue a claim in another state, and there's some case law about what that means, how far you got to go, you are really barred from coming back, from hopping back to Tennessee for more benefits. So what really happens is not that the claims, you are not receiving simultaneous benefits at once. Although I would say you would need to file the claim in Georgia within a year still. That's what this argument is about.
But let's say you do. So let's play that out. You file both, and you don't want to run afoul of Tennessee's bar of simultaneous. Right. So you file both, and then what do you just tell Georgia's workers' compensation? I know I filed it, put it on the back burner. I'll let you know when I went. They're not going to just sit on it. I mean,
well, there is a body of law that addresses it. So you would pursue the claim, and strategically, this is what I would do if I was a claimant's attorney. You would pursue the claim in Tennessee first. They have a higher comp rate. They use the 6th edition AMA guides. I think weekly you get more benefits in Tennessee. At some point, you will hit MMI there. Then you come to Georgia. You get your benefits reinstated. You might have another argument about whether you want to change doctors or not. But when you file that 14, notice of claim is probably what it should be. You're tolling the statute of limitations, and then you have a 5-year statute of repose. So it is going to hang out for a little while, but you have quite some time. Right. So you could still, you have plenty of time to wrap things up in Tennessee. You can settle part of your claim, which this claimant did, and you can come back here. And he could have done that here. But he did not toll the statute. Right.
Okay.
Right. And what I'm putting forward is if you sort of allow this logically to happen, you're going to start hitting all of these inconsistencies, and these two state laws are going to butt up next to each other. If you're saying, okay, we accepted this claim in Tennessee, that's payment of benefits. So now the claim is forevermore compensable now in Georgia, right? Because when you pay indemnity benefits, that's meaningful in Georgia. That means the claim is accepted as compensable. As an employer insurer, you can't just deny the claim for any reason. You're very limited on how you can deny it, the standards you have to reach. And so what I'm saying is, if you're saying payment of TTD in Tennessee is the same thing as payment of TTD here to toll the statute of limitations, then to be consistent with our body of law, you must be saying payment of TTD in Tennessee is the same thing as paying TTD in Georgia, and boom, you've made that claim compensable immediately. And that cannot be the case because we have different laws in Georgia, not only different standards of the amount we pay people weekly or what AMA guides we use. We have state crafted defenses like Maloney, Rycroft, our intoxication standards, things like that.
Did Mr. Hollis get Georgia benefits solely because he had been getting Tennessee benefits? Or was there a full-blown hearing, or whatever we call it, where Mr. Adkins, did you represent Mr. Hollis before the board and the appellate division?
Yes, I represented Mr. Hollis for the Tennessee claim. He has not received any benefits as part of the Georgia claim because when we filed into Georgia, Averitt controverted the claim, and the sole basis was lack of jurisdiction under 34.982A.
Okay. So no, it was never about the merits of the claim or if he still has a disability or anything like that.
No, this is an appeal of a motion to dismiss by Averitt that was denied and then issued a certificate of immediate review.
Yep. So then I think we can still answer my question. I just didn't realize it hadn't reached that point. In order to get benefits in Georgia following the end of benefits in Tennessee, assuming for a minute that there's not a statute of limitations issue, would he not still have to demonstrate his eligibility for them? Or does he simply say, look, I was getting them in Tennessee, so you've got to give me those benefits in Georgia now?
No, Your Honor, we're still on an active all issues hearing calendar down at the trial level in front of Judge Drew. So if this appeal is resolved and the motion to dismiss remains denied, and Averitt does not voluntarily accept the payment of benefits in Georgia, we will have to go to an evidentiary hearing and prove his entitlement under Georgia law to those benefits.
Okay, then I guess I missed, Ms. Ivy, part of your last point there, because and you were using your acronyms, not mine, TTD.
Right.
But what I was taking from your argument was, gosh, if you take this to its conclusion, the fact that Mr. Hollis got benefits in Tennessee means he'll automatically get them in Georgia. All he has to do is apply, and that can't be the system. And it doesn't sound like it is the system. He would still need to demonstrate to the Georgia workers, the board, that he is eligible, that there is some condition that still needs treatment for which payment is required. But if instead he was fully healed and able to do an Ironman triathlon, then Georgia would say, no, you don't get them, even though you got some in Tennessee. You happen to get better, which we want to celebrate. Whether you drive for Averitt or not going forward is up to you. So what did I miss about your point?
Right. So the point there being just the logical inconsistency that comes up. It is true that he would have to still bear the burden of proving his claim here. But what I'm saying is there's nowhere in our code that is going to say payment of TTD or indemnity benefits in another state counts to toll the statute of limitations, yet somehow does not count to make a claim compensable. It would be an inconsistency to hold it that way, is what I'm saying. If you were to rule, okay, as the appellate division said, the employer insurer paid benefits, they paid it on account of the injury, that counts to toll the statute of limitations. Well, then why wouldn't that, implicit in that reasoning is you saying the payment of indemnity benefits in Tennessee is just the same as it is in Georgia. And the appellate division had said that in their 2011 decision. They said, by the employer includes payment of benefits pursuant to the work comp laws of any particular state. And if you take that out to its logical conclusion, then payment of indemnity benefits in another state, that triggers more than just barring a statute of limitations here. That triggers, if you're saying that's the same as paying indemnity here, well, that means I've accepted the case as compensable. Or if somehow we're saying, no, he needs to still go prove his claim and all that. If I'm the claimant's attorney, I would hop up and say, hey, they've already paid. This is by the employer. We don't even need this evidentiary hearing. They voluntarily accepted it when they paid under the laws of Tennessee.
But has anyone said that and been successful in saying that? Or is what really happens if your client doesn't accept it as compensable, that there's another evidentiary hearing, because it could well be that your client, Averitt, has concluded he's all better. He had a broken leg, and that's compensable, and it took a while to heal, but he got 2 years of benefits from Tennessee. And so we get it that because there was a stream of payments, weekly benefits under 34,982A, the clock was stopped, and he has timely applied here in Georgia. But we're not going to roll over and say because he was eligible in Tennessee, he's eligible here. Look, he just walked into the hearing room and he didn't even have a cane. So they're going to have to demonstrate that he is still eligible.
But he didn't stop the clock because a claim has to be filed here.
I understand you say he didn't, but you've created this boogeyman of, look, what's going to happen is that the board is going to accept the findings of some other state's board that it was compensable. And it's going to be, I'm going to call it the law of the case. Because in Pennsylvania, they decided that it was compensable, then Georgia has to accept that finding. And my question to you was, is that how it's played out? Because this can't be the first time you've bumped into someone who's saying, no, the statute didn't run because I was getting weekly benefits in another jurisdiction. And now I've come to Georgia to get my benefits because I have a basis to do it. This is where the accident happened, or this is where the company is located. Here it's where the accident happened. What occurs when a claimant says, no, I don't want to have an evidentiary hearing. Pennsylvania already decided it was compensable. Does the Georgia board say, oh, you're right, and the lawyer for the employer just rolls over? Or does it not happen that way? And if it doesn't happen that way, then your boogeyman seems to be a false boogeyman.
Sure. I have not had that actually come up, to be honest with you. In all of my cases, a 14 has been filed timely. I also did not find a case directly on point. If you go back and look at what we've cited in our briefs.
No, we didn't either. It would be easier if there was a case directly on point.
Right.
We are going to be that case.
Yeah.
Right. Right. Well, I just think you create these problems. You create this problem about forcing Georgia to accept a claim as compensable. And as I mentioned earlier, what about the denial? I mean, you can't have it both ways. You're allowing payment of benefits in Tennessee to sort of deem a case compensable or let you do that. But what about MMI in Tennessee? Then we can deny further payments there, but not here. They're just inconsistencies that come up.
Okay. All right. Well, it does sound like we're hitting on a couple issues that need some appellate clarity. Anything else, Ms. Ivy?
No, Your Honor. Just, I'd urge you as you sort of look this over to really look at some of the cases the appellate division has cited to support their argument, and none of them are really on point. I mean, you'll see they're dealing with different issues. I could give you examples of those, but they're cited in my brief too. They're distinguished. Right. So I would just sort of urge you to look at those cases directly. Okay.
Thank you. Mr. Adkins, want to hear from you. I don't think you need to argue the timely, not timely in terms of 34.9.105B, but I want to preclude you from that. I think I understand your perspective. But I am interested in addition to the 34.9.82A argument, you made an argument that Georgia has jurisdiction because the Averitt admitted jurisdiction in a request for admission, and so they waived the statute of limitations. I want to hear you amplify that a little bit. And then I've got another query that gets to the board's procedures. We are here having this conversation under 34.9.105B, which allows an aggrieved party to appeal to Superior Court. But as I read it, they may appeal a final award or some other final order or judgment. I don't know that that's where we are procedurally. There was a motion to dismiss that was denied. That could be challenged in the future, but I'm wondering why I have jurisdiction to consider this discussion because there's nothing final from the board. If I grant Mr. Hollis the relief, if I deny Averitt the relief it's seeking, we still need to get a decision from the board. There isn't. They've simply decided this one little procedural thing and nothing substantive. So I said that less efficiently than I should have, but I'm wondering if really what I ought to do is say, you got here too soon. There's not a final judgment or final decision. So nothing for me to rule on. Head back to the board, duke it out over the merits, and then see how that goes. And on appeal of the merits, if it doesn't go well for Averitt, you could work through these issues that we're here talking about. Does that question make sense?
It does make sense, Your Honor. What would you like me to talk about first?
That last thing I said, because we don't really need to worry about did someone waive jurisdiction? Because if they waive jurisdiction, or waived the statute of limitations argument. We still need to work through other arguments that were raised, but we don't work through anything if I really ought not to be hearing this because Averitt has appealed from a non-final judgment.
So my understanding is that when an interlocutory order is entered and then a certificate of immediate review is issued, that the appellate court system can then hear and rule on the issue as we go up. And normally in what I like to colloquially call big boy court, that would start in state or superior court, then go to the Court of Appeals and so forth and so on. But in a workers' comp context, the Superior Court is acting as an appellate court. So I think it would be functioning in that posture where, the certificate of immediate review allows for the appellate pathway.
Okay, and you've added a piece that I missed in my review. I didn't realize they issued a certificate of immediate review. Do you have that somewhere? I'm not seeing it.
It was I believe that it was part of the board file. I'm not sure if it was transmitted, but it's what gave the appellate division jurisdiction to hear.
Yeah, I guess I'm there is the ALJ said you may appeal me. Here's your certificate of immediate review. That got you to the appellate division, but those don't. I promise you the Supreme Court will tell you that doesn't get you to the biggest boy court. Just because the Court of Appeals says we'll listen to something doesn't mean then that you get to go to the Supreme Court. So ALJ said you may appeal me now. I'm not ruling on the merits. You may appeal me to the appellate division. What did the appellate division do or say that made Averitt think they could get here?
Respectfully, Your Honor, I feel like that might be a question for Ms. Ivy, but I can't.
It is. It's just, I'm going to want to hear from her, but since this was actually it's a low impact win, you shouldn't even be hearing this, Judge. We didn't need to dive into the rest of your argument.
Well, to be frank, in reading the appeals order, there was not another certificate of immediate review that was issued. So, and again, to be frank with you, your point caught me by surprise, but I would argue.
And I'm not playing gotcha. This just slid across to me, so I wasn't laying in wait, and it may be that that's a homework project for both of you, so that I don't overstep my bounds. I don't mind wading into this. It's interesting, and there needs to be guidance. It won't come from me. It'll come from the appellate courts. But I don't want to be out ahead of my skis. It would be awkward if I enter some ruling and it bounces up one level and they say, silly trial court, you didn't even have jurisdiction to be considering this because the appellate division, there wasn't the appeal from the appellate division was without foundation.
So, again, I have not researched the issue, but I think it would come down to whether or not administrative law, for the purposes of appellate decision, is treated like cases are in the normal court system, where, because I know that in, for example, like general civil litigation, you would need a certificate of immediate review from the trial court, but you would not need to obtain one from, say, the Court of Appeals to go to the Supreme Court. So if that's the way that it works, then you would, under normal circumstances, have the ability to make a ruling, though I would argue that the time for that has passed, and I'll get to those arguments in a minute. But, if that is not the way that it operates, then it may be that Averitt made an error, tactical error, by not securing a certificate of immediate review by the appellate division, and this is all moot.
Okay. Ms. Ivy, I was going to leave you alone until we got through all of Mr. Adkins's presentation, but I am going to share my screen so we're all talking off the same thing. All right, you should be able to see it there, and I go to annotate. So it's a final award. Oh, so that just made it go away. That wasn't helpful. Should underline it. So a final award or any other final order or judgment. So what was final other than that they ruled? I appreciate that the appellate division said, here is our ruling, but it's interlocutory. They were simply saying, we're not dismissing, you got to go forward on the merits. How do we navigate 349105B?
Yeah, I think I'm sort of in the same shoes as Alex. I think I would need to research this more as well, frankly. I don't see any. All I can sort of think of right now is there is a process in the act where it is clear and we are instructed to seek that certificate of immediate review when moving from the sort of ALJ level to the appellate division level, and that's not contained in 105. But
Whoops.
frankly, I think it's a very fair question that perhaps we would have to research. I have not really been asked that or had that issue come up before.
Okay. Well, I'm going to table it for now. I want Mr. Adkins to make his presentation, but I'm going to need to hear from both of you. Doesn't need to be a brief. It can be an email to Ms. Niles saying, hey, I looked at it. I can't find anything, but here's why we win, or here are two cases to look at. But it is not just food for thought, but something that I think we need to work through. All right, Mr. Adkins, back to you.
Yes. Okay. So at this point, I will start off because I believe Your Honor wanted me to do this, that about the admission. Okay. So this, to be honest with you, this is sort of a vestigial argument that came from the motion to dismiss and the objection thereto. But essentially, at the beginning of the Georgia case, there were some requests for admission that were sent and admitted, one of which is that the board has jurisdiction to hear this. And the argument is that statute of limitations it eliminates jurisdiction from a court to hear a matter. But also subject of limitations arguments, rather than as opposed to statute of repose arguments, are waivable. And by admitting in judicio that the board had jurisdiction to hear the case, Averitt essentially waived their statute of limitations defense.
Okay.
So that's the argument there.
All right.
I did want to go back to the timeliness of the hearing because I think there is some additional context that would be helpful for the court. Ms. Ivey's absolutely correct.
Timeliness of this hearing.
Yes.
Yeah. Okay.
Ms. Ivey is absolutely correct that prior to 1997, the standard was that a hearing had to be heard within 60 days of the filing of the notice of appeal. And in 1997, they changed the statute. And essentially, from a procedural perspective, how it would work is that when the appellate division issued a decision and a party was aggrieved and wanted to appeal, they would file a notice of appeal with the state board. Then the state board would transmit that appeal and the record to the superior court where the injury occurred. And when everything arrived, it got docketed, and that was when the 60-day timer started. In 2022, the General Assembly amended 34-9-105 to make it fit within conformity of OCGA 53-1 and sequential. And so now, instead of filing a notice of appeal with the board, an aggrieved party files a petition for review with the superior court. And in the context, or in the language of the statute, which was just on the screen, but I'm looking at it right now on my screen, a little farther down from where Your Honor highlighted it, it says, a copy of the petition for review shall be served on the clerk for the board. In the event of an appeal, the board shall, within 30 days of such service, transmit certified copies of all documents and papers in its file, together with a transcript of the testimony taken and its findings of fact and decision to the clerk of the Superior Court to which the case is appealable, as provided in this subsection. So the argument, the procedure has changed not just from 1997, but from July 1st of 2023 when this law became in effect. And you can see from the plain language of the statute that the transmission of the board file is different from the filing of the petition for review. Now, this may create some problems that the General Assembly needs to fix down the line, but that's not really our place today to decide that they should do that. But the date that the appeal is docketed is plain language, the date that it is added to the docket. And the fact that there is a separate sentence talking about the transmission of the board file it differentiates the receipt of the board file from the date of docketing. If you look at the Court of Appeals decisions that I cited in the brief, they are taken from 2017 and I believe 2015, which would be after 1997, prior to 2023. But in both of those decisions, they were not looking at when the board file was received. They were looking at when the appeal was docketed. And so, the plain meaning of date of docketing is when it is added to the docket and assigned a case file.
What is added, though? It doesn't say. I mean, that's what we have to work through here in a effort to harmonize 349105 with the relatively new Appellate Procedures Act. They added this language, but it says 60 days of the date of docketing of the case, of the appeal, of the record from below. It doesn't say does not hear the case within 60 days of its docketing. It's the date of docketing. And so aren't we left, we're having to surmise, what did the legislature intend, docketing of what? And then I think that gives us some of the leeway to engage in some of the concerns that Ms. Ivy read, which is if it's of the case, as in the appeal, then you've got at least 30 of those 60 days chewed up because the record from below is not even due for 30 days. I guess court should be trying to schedule it, even though they don't have the record and they don't know if the record is 100,000 pages or 60 pages.
And Your Honor, they should be trying to schedule it because the statute does provide for that. It says that the hearing can be scheduled and then continue to a date certain. Mm-hmm. So it's not a hard and fast rule that you only get 60 days. As long as it's continued to a date certain, you can allow for those delays. And I'll also point out that in one of the cases that I cited, actually I believe it was both the cases that I cited for the Court of Appeals, Boriquez, I'm sure that I am butchering that name. In that case versus MFG Chemical, the Court of Appeals didn't even know when anything was done. Like they had no record to go off of. So they went off of, this is when the appeal had to be done from the appellate division to Superior Court, and therefore it was affirmed by operation of law 60 days later. Mm-hmm. There was no discussion of when the board file arrived. It just was not a part of their analysis whatsoever. So, I would say that is informative to say that it should not be considered here. Electronic filing kind of changed things a little bit because when 1997's amendment came around, people were still doing things, either in-person filing or mail. And so there was consequently quite a bit of delay in the proceedings. But, this day and age, you file on Odyssey and it is time stamped and date stamped the exact same day. And that is probably something that the General Appeal or the General Assembly should account for. But like I said, that's not really the question that we're here to fix today.
Okay.
So That's the argument on whether or not it's timely. You know, it's our position that it's not, and that therefore it's already been affirmed by operation of law, and therefore any order would be a nullity. But you know, getting to the merits of the case, and just to give you a little bit of factual overview, like Ms. Ivy said, the facts are not in dispute, and also. And I'm getting a little flustered here, so let me take a breath and reset. In workers' compensation law, there are typically three kinds of benefits. There are weekly income benefits that you receive, which are called temporary total disability or temporary partial disability. There are permanent partial disability benefits that you receive due to a permanent impairment in your body. And then there's medical treatment. And the statute of limitations in 82A states that an employee that is injured has to file a notice of claim in Georgia within 1 year of the date of accident, except that if the employer pays income benefits, which would be temporary total, temporary partial, or permanent partial, they have 2 years from the date of the last payment made on account of the injury by the employer. And if the employer pays medical treatment, they have 1 year from the last date of medical treatment furnished by the employer on account of the injury. There's no language in the statute that talks about pursuant to Georgia law. And as a practical matter, many times it is the employer and their insurance company that initiates payment of benefits without pursuit of those benefits by the employee. In a court posture, an employer occupies the space of a defendant. But in the practical practice, in practice, many workers' compensation carriers accept a case as compensable and begin payments based on their choice of jurisdiction, not the employees. And that is what happened in this case. Averitt decided that they were going to pay benefits, and you know, whether it is pursuant to Tennessee law or pursuant to Georgia law, they paid them. Now, the case, the permanent partial disability was eventually settled under Tennessee law. But since that time, Averitt has continued to pay medical treatment to Mr. Hollis. As recently, I believe, as December of last year. So every state is only responsible for what that state's law is. And I think Ms. Ivy's argument is more of a legislative argument that the General Assembly should adopt the choice of remedies doctrine that Tennessee has. Because in Tennessee, if you seek benefits from another state, you are automatically barred from any benefits in Tennessee. So, you know, the proposed solution of filing in Georgia could have jeopardized his benefits in Tennessee as a practical matter.
So
But
you would not encourage, based on Tennessee's law right now, a client to apply for benefits in Georgia and Tennessee simultaneously.
No.
Even though they might table the Georgia one because of what Ms. Ivy described as the 5-year statute of repose, because Tennessee might find out about the application in Georgia and say, well, we're done here. You go do your Georgia thing, but you're already seeking benefits there. You've chosen a remedy. I hope it works out for you, but you've chosen Georgia, so Tennessee is not a place where you're going to get benefits.
That was our fear in this case.
Okay. Have you had the scenario I asked Ms. Ivy about, which is you exhaust your benefits or decide your benefits are done in a different state than Georgia, then apply in Georgia, making the argument you did, which is under 34,982, the statute of limitations hasn't actually started to run, or it just started because last weekly benefits were paid 2 months ago. So we're well within the 2 years or whatever it would be. And then Georgia says to your client, yeah, and you win on the merits because you were getting benefits in Tennessee. You don't need to demonstrate merits here.
No, I don't believe that would happen, Your Honor, because the way that the statute is written, which would be 349221, I believe it's 221H. It says that if benefits are paid pursuant to this statute, not pursuant to the jurisdiction of any state. So if you were to be in another state and then come into Georgia, you still are in what we call an all issues posture, where the claimant has the burden of proof to show that they sustained an injury arising out of and in the course of employment, and that they're disabled from that injury in order to receive benefits under Georgia law. It's not an automatic win. Now, based on the facts of the case, that is for the trial judge to determine. But there's nothing that says that benefits paid in another jurisdiction automatically confer the acceptance of a claim in Georgia. The only language I can think of that even talks about benefits paid in another jurisdiction, specifically another jurisdiction, is that if it's actually, I believe it's 349245, and it says that the employer will receive a credit for any benefits owed in Georgia for benefits paid in other jurisdictions.
Okay, so if for whatever reason the Tennessee stream of benefits was ongoing, and the Georgia board says, Averitt, you owe Mr. Hollis $500 a month, but it turns out he was getting 200 from Tennessee, then Averitt would only owe 300 a month in Georgia.
Well, I understand the math, Your Honor, but as a practical matter, what would happen is once Georgia ordered $500 a week, Tennessee would then cut off all benefits.
Right, because he's getting
Georgia.
Yeah.
Yeah.
Okay, but if it was a state that didn't have a choice of remedies, it's Connecticut. They love everyone. So Connecticut's going to keep paying. The way the Georgia statute would operate is that if Connecticut was paying 200 a week and Georgia ordered 500 a week based on the evidence you were able to present, Averitt would only need to pay 300 because they could point to the 200 coming out of Connecticut.
Yes. Well, first, they would have to pay 300 for every week that the claimant already received the 200 from Connecticut.
Oh, it would go back in time.
Yes. And then going forward, depending on whether Connecticut continued to pay, it would be 300, or if they stopped, it would be 500.
So could Mr. Hollis get money from Averitt for the last 2 years if Georgia assuming you get to go forward and on the merits you demonstrate he's entitled to some benefits going forward, if that figure is greater on a weekly or monthly basis than what Tennessee was paying, you're saying Averitt actually would have a debt for the preceding months, even though Mr. Hollis had not asked for Georgia coverage for those preceding months?
In that hypothetical, yes. However, in our current case, Mr. Hollis was paid more than what Georgia law allows, so the credit would be full and they don't owe anything until the date that the benefits were suspended.
They're in.
Because the basis under which benefits were suspended in Tennessee is not a valid basis to suspend benefits in Georgia. But that's really not a question before the court. It would, but to answer your question, yes.
Okay. All right. So I had cut you off. Was there anything more you wanted to say about being able to move forward on the actual merits of the claim?
Only that, in many of the cases that we cited, it is a very bedrock principle of Georgia law that if the General Assembly wanted to add qualifying language to a statute, the courts will say that if they had wanted to, they would have. And therefore, if they wanted to add the term pursuant to Georgia law, they absolutely could have done so and chose not to. I'll point your honor to Kemp versus Kemp from 2016. Quote, thus, we must presume that if the General Assembly had wished to allow beneficiaries to seek attorney's fees at any time during the litigation, it would have expressly authorized them to do so. As a result, we must also presume that the General Assembly's failure to do so was a matter of considered choice. So the argument from Averitt that it is implicit that benefits be paid to Georgia law is in conflict with what the Court of Appeals has said about the General Assembly's intention.
Well, what if it is where it falls? 982 falls within a larger framework of statutes about workers' compensation, and there's been reference to weekly benefits in all the statutes, and it's always been in the context of Georgia pays weekly benefits. Georgia doesn't pay weekly benefits. Are we to look at 82 in a vacuum as if it's the only statute on the books? Or do we weave it into its neighbors? Because, of course, there's the Workers' Compensation Act or whatever it's called that is, I don't know if it's all of Chapter 9 or if it's more than Chapter 9, but it's certainly Chapter 9.
Well, I think that opens a very big can of worms, Your Honor, because at that point you are litigating the factual matter of what is pursuant to Georgia law. Is sending someone to the doctor to be evaluated in Georgia, but you say it's a Tennessee claim, does that make it benefits furnished under Tennessee law? And who gets to make that decision? The way that the General Assembly worded it is that it is payments on account of the injury. And I think basing it on the work injury solves the problem of litigating what is pursuant to Georgia law. Because yes, you can argue that benefits may or may not be, like income benefits, you might be able to figure out the factual nature of what state they were paid under. But medical treatment is medical treatment. If you have a Georgia claim with a Georgia claimant receiving treatment in Tennessee, is that pursuant to Tennessee law just because the doctor's in Tennessee? Or is it part of a Georgia claim because the claimant is in Georgia and the accident happened in Georgia?
Right, or you live in Ringgold and it happens to be the hospital you go to is across the border. It's the closest hospital. Does that suddenly mean you're not in the mix?
Right, and that is solved by the phrase on account of the injury.
Okay.
Like I said before, there are times where the employer has absolutely no idea that an employee was hurt at work and then until they file a claim. But there are plenty of times where the employer and their insurance company is well aware of the injury. They've decided that that it is compensable without any litigation. And I think that it is a very dangerous precedent to set to allow the adjusters for the insurance company to dictate the jurisdiction of where claims go when employees have absolutely no knowledge that it's happening. Just that they're getting benefits or that they're seeing a doctor. And so, in the position that the employer occupies as a defendant in these case captions, that's essentially tantamount to allowing defendants to choose jurisdiction and venue of cases, which is, absolutely the opposite of how the judicial system works. I think that the General Assembly was very clear about the statute. And I would just add that in this appeal and beyond, the court is constrained by the any evidence rule, which states that if there is a factual dispute in an appeal and there is any evidence to support the prevailing party in the lower court, the decision must be affirmed. So the question of whether or not these payments were made on account of injury, that's settled by the lower court. They were. So it's just a matter of reading the statute's plain meaning and applying it. And I think when you do that, the motion has to be denied.
Okay. Well, that's what the appellate division thought. Ms. Ivy, anything, you are the petitioner, you represent the petitioner here. Anything you want to add on any of the arguments you made or something that's come up during Mr. Adkins's presentation?
Sure, Your Honor. Just a few brief points here. I think you were completely correct when you noted that it is still critical to consider the context in which this statute's written. It's in the Georgia workers' compensation law. It's about Georgia benefits and Georgia claims, and you must abide by Georgia law and Georgia procedure. And that required a filing of a claim in Georgia. And so you and Alex were speaking earlier, this concern about was filing a claim here going to bar him from further benefits in Tennessee. That is not accurate, I would say. Again, I'm not barred in Tennessee, but I'd urge you to look into this some. It's my understanding from defense counsel we work with in Tennessee that the election of remedies doesn't kick in until some affirmative steps are taken to pursue the claim in Georgia. So again, the remedy here was filing a 14 notice of claim. He didn't have to file a hearing and take depositions and start pursuing benefits. You could have filed a notice of claim, told the statute here, pursue everything in Tennessee, then hop back here to Georgia. We would not be here today for that. So there is something that could have been done. And as far as the confusion of, well, how do we know if we're paying benefits in Tennessee, in Georgia, and what all that means? We know it at every turn. There are different compensation rates. There are different fee schedules that are used. There are different AMA guides that are used. And actually, if you look at the Tennessee settlement, you'll see that there's an affidavit from Mr. Adkins where he's justifying his fee in the Tennessee settlement. And he talks about discussing the intricacies of Tennessee law to a doctor who practices in Georgia and is not versed in Tennessee law. He clarifies with the authorized treating physician to use the 6th edition, which Tennessee uses instead of the 5th edition in Georgia. He clarifies how the claimant's unable to return to his pre-injury occupation under TCA 50-6-242. These are all examples of how it is so different between Tennessee and Georgia. And yet now that you've missed this procedural deadline, you want to come here and say it's the same thing, and it's not.
All right.
Can I say one more thing?
If it's brief.
It's very brief. If you take income benefits out of this and just talk about medical treatment, there's absolutely no way to distinguish Georgia from Tennessee payments, because Tennessee doesn't even start paperwork on a claim until there is some settlement of income benefits.
What state in the Southeast is most generous with workers' compensation benefits?
That is a fantastic question. I do not know the answer to. I can tell you the differences between Georgia and Tennessee.
You did. You said Tennessee pays more, so that's why.
They pay more weekly, but they also suspend benefits when you reach a maximum medical improvement. Georgia has a lower compensation rate, but does not stop benefits when that happens.
Well, how about Averitt? When do they like, oh no, not that state. We don't want to do workers' comp. We're running to Tennessee because boy, that other state, they hand it out like candy.
Averitt is actually not as malicious as they've been portrayed to be. Maybe they accept all, which, but I'm just saying, they accept all their claims in Tennessee to begin with. They don't cherry pick. They are housed in Cookeville. Their adjusters are in Cookeville. They're Tennessee adjusters.
So that's home base.
That's home base, right? Yeah. And there are other differences, and not just indemnity, but I understand different medical benefits. Claimants get lifetime medical until they settle it. Georgia's capped at 400 weeks unless you're a catastrophic claim. So again, there's tons of differences.
Okay. Well, this has been educational for me. You all are going to get to educate me on one more issue, and you just need to let me know how much time you would like to get an email back to Ms. Niles, obviously copying your colleague here, about your thoughts, product of any little bit of research you want to do on this threshold question of, do I even have jurisdiction to hear this petition because it is not a challenge to a final judgment or final order from the board? Ms. Ivy, how much time would you like?
So this is, well, we do have America's 250th birthday coming up. So
We do. It's a choppy time. That's why I'm asking.
I'm really amenable. 2 weeks, 3 weeks. Is that outrageous?
Mr.
I'm fine with whatever amount of time Ms. Ivy needs. I'm fine with that.
So you want to say the 13th or the 20th?
How about the 20th?
20th it is. And again, this is not, you don't have to e-file anything. It's an email to Ms. Niles, copying your colleague here. saying, here's what I got nothing, or here's some thoughts. There's nothing quite on point. Here's an analogous, whatever you come up with.
Great.
And I will hold off on the rest of this until we can get that piece.
Thank you, Your Honor.
All right.
Yeah, thank you, Your Honor.
You're welcome. I appreciate this was very helpful. I'm not going to do much workers' comp going forward, but it's always good to get a peek under the hood as to what's going on in related fields. We'll look for those emails in a few weeks. And so I will let you know through Ms. Niles if I think it's pretty clear cut. Then Ms. Niles may send you an email saying, here's how the judge comes down on it. And Ms. Ivy, you're going to send in a proposed order because you carry the day, or Mr. Adkins, you're going to because your position carried the day. It may be that we keep it in-house, but if not, we may ask for a little assistance from one of the two of you.
Yes, Your Honor.
Okay. Anything else for Averitt?
Nothing else. I appreciate both of your times. It's informative to me to hear the questions. I know Alex is a great attorney. It's been great working with him. So the more we go back and forth, the more I learn every time.
Excellent. Mr. Adkins, anything else?
I did, just in case anyone saw me shaking my head while Ms. Ivy was talking, that was not disagreeing with any point she was making. My 5-year-old daughter is here at home, and I was trying to tell her that she didn't need to get a pickle. So please don't read anything into that.
Oh,
All right. The perils of working from home. Thank you for sharing that.
Thank you.
All right. You all take care. I'll see you soon.
All right. Thank you.
bye.